Good morning, good afternoon, good evening, and good night, friends and colleagues from across the world. Today we have a special edition podinar with one of our chairs, our beloved Dr. Pavel Krastev, who's going to be the acting co-sponsor, and Mr. Thomas O'Rourke, an attorney with over 30 years of experience, who has come to the table today for this special session to inform and educate our colleagues about the processes of intellectual property. Innovation. As you guys may know, innovation is the lifeline of any sustainable operation. We live in a world of obsolescence where things become old. No matter what anybody says, what once was a great invention is no longer the best invention in its class because we have had new innovations. So when our friends and colleagues, both Dr. Krastev and I are inventors, we have patents, trademarks that we work with, and there's a very big learning curve and finding your right mentor, an attorney to work with, to be able to implement and institute it into commerce. And your intellectual property is just as important as your innovation and your ideas. Everybody has ideas, but only the ideas that are properly taken to the course make it to the marketplace, and they make it and become house brand names. Healthcare. So thank you, gentlemen, for taking the time out of your day to join us for the benefit of our colleagues. We really appreciate it.
Hello, everyone. Tom, welcome on board here. We appreciate your sharing your time with us today. Keanu, Dr. Keanu, thank you for having us. And on behalf of Global Summits and all of us guys, we welcome you. So today we have a little bit of a different lecture for you guys to learn from. And most of us focus on dentistry and implantology and whatever our specialty may be. But, you know, being healthcare providers, we have different specialties. We work in different branches of healthcare. And sometimes we come up with ideas. We come up with some innovation in our minds of what we think can make our particular specialty better, stronger. Bring something to the table for our colleagues to do particular procedures in a different, more safe way, perhaps, that may better the human race in general. So what happens is when we are facing this road, we come up with questions. Do I know how to do this? What is involved? How much does it cost? If you do pursue a product, an idea in your mind, do you need a prototype in order to file for a patent? Do you need any supporting other documentation, drawings, etc.? What does the process entail? Does intellectual property, is it limited to a copyright, to a patent, to a trademark? What are the differences? So these are very important questions that we need to address. And in healthcare, I encourage all of you guys, don't be afraid when you have an idea. Do the right thing and consult with the network of friends that you have. And I'm sure you'll find an individual or a few individuals that will sort of guide you through the process so that you don't fear the unknown. So I think as dentists and as doctors and as nurses, we all sometimes stay in our boxes and are sort of intimidated by pursuing something in the unknown territory. So today I think we'll have a great presentation with Mr. Thomas O'Rourke, a dear friend that I've had the pleasure to work with in the past. Great guy, great knowledge, and I look forward to this Q&A session that we're going to have today. But once again, folks, in healthcare and in all other branches, when you have an idea, explore it. And you never know. So, Tom, welcome to our show and to our Global Summit project. And ladies and gentlemen, while we have Tom here, maybe Tom say hello, and then I'd like to go through your resume and read to our audience who you are, a little bit about yourself.
Good morning, everyone. Thank you for having me. I look forward to imparting a bit of my knowledge in this area and hopefully answer the questions that you have. It's a very hot topic these days. Intellectual property is the lifeblood of the country, and whatever can be done to protect your intellectual property is very important. We'll go through what are the different types of intellectual property. So, for example, There's patents. They cover inventions. The inventions can be very broad, can be a lot of different things, can be processes, can be devices, can be chemical compositions, drugs. We're going to talk about trademarks. Trademarks are a brand. They're the name of a product. There's a lot of different ways to protect that brand. We're going to talk about copyrights. Copyrights typically are things that are artistic, but can also include software. Can cover dance, music, books, things that you write. And then we're going to briefly talk about trade secrets. Trade secrets is something where you get a benefit of using a technique or a product and you don't let anybody know about it. They can be very valuable, but they're very difficult to protect.
Excellent. So, ladies and gentlemen, let me just go through Tom's resume, and then we'll start the discussion. So, Thomas A. O'Rourke is a founding partner of the firm Butler and O'Rourke. Mr. O'Rourke practice involves all areas of patent and trademark and copyright law. For over 30 years, he has been registered to practice before the United States Patent and Trademark.
Educate our colleagues.
Mr. O'Rourke has counseled clients regarding the procurement and enforcement of patents, trademarks, copyrights, and trade secrets in a variety of technologies, including mechanical and computer technology. In addition, his practice involves domestic and international technology transfer, acquisition, and licensing. He is a member of the Bar of the State of New York and California. He has also been admitted to numerous federal district courts and courts of appeal across the country, including the Court of Appeals for the Federal Circuit. Mr. O'Rourke has been a member of the Board of Directors of the New York Intellectual Property Association. Mr. O'Rourke is co-chairman of the Suffolk County Bar Association Committee on Intellectual Property Law and has been a member of the advisory board of the Licensing Journal. He has lectured on intellectual property law at numerous continuing legal education programs, including programs presented by the American Bar Association, the Connecticut Intellectual Property Law Association, and the Suffolk County Bar Association. He was also the editor of the New York Intellectual Property Law Association Bulletin and the author of numerous articles on patents, trademarks, and copyrights for the New York Intellectual Property Law Association. Mr. O'Rourke has authored monthly articles on intellectual property, law licensing, which have appeared in the Licensing Journal. Mr. O'Rourke has also been named as a super lawyer. Great accomplishment, Tom. Mr. O'Rourke has a Bachelor of Science degree in chemistry from Fordham University and obtained his JD degree from St. John's University School of Law, where he was a member of the Law Review. I went to St. John's University back in the day for my undergrad. Anyway, welcome, Tom, and that's a very impressive resume. So where do we start? I mean, should we begin our discussion to explain to the audience, first of all, the difference between a patent, a trademark, and copyright? And then perhaps you may be kind enough to explain the different types of patents, utility patents versus design patents, which one carries more value and why. And perhaps just for the audience to understand, maybe you should mention something about the fact that there are patents for plans for, different things get different amount of protection, the amount of years, and what the process involves in general. And, Dr. Shah, please, I mean, you've, one thing I want to mention, guys, before we start, I guess, is different persons have different strengths and different inclinations to pursue different areas in their life. So some of us write articles and are experts in the literature, which I'm certainly not. Dr. Shah has a futuristic kind of mind that can do 9,000 things at once. I can't do that. Tom is a master of his own science, I'm sure. And, so how do we bridge all this together through the doctor platforms, So here we are. Let's rock and roll, guys. Welcome.
So trademarks. I think, Dr. Pavel, you have a tremendous number of patents. They're quite more complex. On trademarks, Trademarks, patents, copyrights. Copyrights, we'll both learn a lot today from Tom. But when it comes to starting with trademarks, to preserve the name of your trade or your business that you're doing, some rules and laws have changed, Tom. From, for example, back in the day, you could take a screenshot of something you put somewhere in commerce, in a magazine or online, and then justify that to the USPTO as evidence of your first usage in commerce. That sort of changed, where first usage rights are no longer allotted. It's who first files, correct?
While in the trademark law is a little different from patent law. Patents, it's first to file is the key. In the old days, for a patent, it was whoever invented it first. And starting in 2013, they changed the law to make it the same as with the rest of the world. The rest of the world has always been whoever wins the race to the patent office gets the invention. In the U.S., up until 2013, it was whoever invented it first. And as a result, there were some procedures in the patent office where people would fight over who invented it first, and they became very, very long and drawn out. For example, there was a case involving polypropylene that started in the mid-50s, and there were probably about 15 to 20 companies who claimed rights to the invention of polypropylene. And it wasn't until the early 80s that ultimately got resolved. So, by going to the first to file rule, they got rid of all those battles over who was the first inventor. And, so they made things simple. It's very important in the patent area that as soon as you come up with an idea, you do something to protect it, because with that change, you could lose out. In many technologies, people are working on the same thing in different parts of the world. And, if you dilly-dally around, you could lose your rights to that invention. So, you really have to, get your ducks lined up and at least file a provisional patent application. You don't need to have the invention fully completed, but you really need to do something to file. And provisional applications can be quick and dirty, can be, done very quickly, particularly if you're going to go ahead and give a talk someplace on the research that you're doing. A lot of times you'll file the paper that you were going to give as the provisional application, because, while the U.S. is sort of liberal about giving you time to file before you lose your invention rights, other parts of the world have what's known as absolute novelty, which means once you reveal the invention in a publication, you could lose all your rights to it, even if you file quickly. So, the provisional application can be very valuable to preserving your rights.
It's very inexpensive too. From what we've been promoting on our podinars is that if you see an issue or a problem chairside with patients or what have you in your clinical procedures anywhere, we want to create the global SUMMIS infrastructure set up to create very smart, business-wise, capable doctors that can think independently and autonomously. So you find a problem in a healthcare setting. You have an idea for a solution. First thing is to quickly file your provisional, which is inexpensive, and getting in with a patent attorney. This can be done even with hand drawings, correct? And how many months do you get? I believe, is it 18 months, 12 months?
No, you only get a year to file the regular application, and that year goes by very quickly. People sit down and say, oh, I got a year. But you really, at the end of that year, you have to file the utility application. Now, a lot depends on the invention that you have. You may need to do further research and development. That's fine. But you would file your regular application based on what you know at the end of the year. And then you'd have to supplement it as you get more clinical data as you go along, other techniques that you may want to protect by filing what are known as continuation and part applications. And you would keep, your filing date for whatever was in the original provisional, but you would file later applications to make sure you fully protect your invention.
What about the strategy that if you had something grand, something really, really big? Because I've known companies that filed in the US, started making their products. Somebody else filed something similar in Europe, and they could not go to Europe because they had the coverage there. So what we did as a strategy one time was to actually file in Geneva under the United States a patent cooperation treaty, which covers in 157 countries for another 18 months on top of the 12 months that you get on the provisional, right?
Yes. So what happens with the PCT application is you can file in the U.S. first, and in many instances, you have to file in the U.S. first because there are certain technology transfer rules that you have to make sure you comply with before you ship an invention overseas, even to file in the PCT. So, you have to go ahead, file first in the U.S., and then at the end of the year, when your provisional or your regular application has been filed for a year, that's when you go ahead and file the PCT. And that PCT is entitled to your original filing date if you file it within the year.
The provisional, right? So that gives you almost
Yes.
30 months from the provisional to have worldwide protection.
Correct.
Yeah.
Okay. But keep in mind, worldwide protection can be very expensive, and you really have to very carefully make your decision as to what countries you want to protect the invention in.
After the 30 months, but you can keep all the wolves at bay for 30 months, right?
Correct.
Okay, very good. Very good. For very inexpensive.
One thing that I think is very important to mention is usually, I believe, from my limited experience with in the theater of patenting things, initially you start with the research, and the research is of prior patents, and once that research is done, usually the person interested in gaining or applying for a patent is kind of advised. Does the research show any prior art or does it not? And then based on that, from there you take it to the next step by filing a provisional, which is going to protect you for a year, as the guys just mentioned. And then, depending on what happens during that 1 year, then you perhaps pursue the utility direction. And I'd like time to explain the difference between a utility patent and a design patent for the audience, and then we can maybe touch on that.
Very important.
Sure. All right. A utility patent is a patent that covers more of the function of the product. It'll cover a drug composition. It'll cover a medical technique. It'll cover computer programs. Design patents are really intended to cover just the ornamental features of a product. All right. So, for example, if somebody is buying a product because of its look, a design patent can be very useful for that invention. Many of you may have interest in furniture. There's a lot of very artistic pieces of furniture out there where you're buying that look, like a Mies van der Rohe chair, the Ames chair. These are things that you might see, let's say, in the MoMA, the Museum of Modern Art. These are products that, an interior designer may be suggesting for your house or for your office or something like that. And the design patent will be the protection that will cover those type of products, because a chair is a chair. It's got a seat, it's got a back, it's got one or more legs. And, what's really unique about that? But, a very specialized, artistic type of chair, there's a market for that, and the design patent will protect that. Design patents also cover things like fenders on your car. All right. So a automobile company may go ahead and get a design patent on the particular shape of the fender so that this way a knockoff manufacturer can't easily go ahead and make replacement parts, because it's the look of that fender, that it matches the Corvette's fender or it matches the Volkswagen's fender. That's very important to somebody, right?
So, Tom, quick question. Dr. Pavel and I think it's very good that we are putting in the feedback from the experiences that we had so our colleagues can kind of get an idea of what could go wrong and what could happen. Design patents are absolute, right? You have claims on your provisional, non-provisionals that you can adjust later. It comes all down to the claims and the provisionals from what I have experienced. Your claims
Yes.
matters. And then on your design, I mean, you design a fender on a car. The knockoff guy can change the design slightly and still can get through, right?
Yes, that's right. But it doesn't have to. It's what the perception is amongst the purchasing public that becomes important. All right. If it looks like it's almost like a trademark type test. Is somebody thinking that comes from the same source, from the design patent? All right. So let's take what kind of changes are they going to make in the fender? If they make too many changes, it may not really look as nice as what you already had on the car. It may not match the rest of the hood or the front door if you start making too many changes. So that's where the design patent can come in very valuable.
Excellent.
Now, one thing that you have to be aware of, design patents can also act as trademarks. There can be some overlap if the product is sufficiently famous. Let's talk about a very ubiquitous product that you're all familiar with. All right. So here's a bottle of Coca-Cola. You have a trademark in the words Coca-Cola. You have a trademark in the specific type of lettering that's on that bottle, Coca-Cola. You see that unique script? You can get a trademark on that. You could get a design patent on the particular curvaceous shape that the bottle has. It has this, comes down and then it goes in there a little bit. You see it more frequently in the old-fashioned glass bottles, the curvaceous nature of the Coca-Cola bottle. That bottle can be protected not just by a design patent, you could also protect it by a trademark. So somebody seeing that particular shape of the bottle could be confused as to thinking that's a Coca-Cola product.
Causing confusion is what the probability or prospect of causing confusion amongst consumer is the question at hand with trademarks and patents. So with trademarks, what does the USPTO look at? Can you explain the dominant portion of the name? Can you explain how it sounds and what it the wording, the acronyms being used? Can acronyms be trademarked and those things? Could you please address the generalities there?
All right. Anything that acts as a source indicator can be a trademark. Okay. There's a lot of things that are out there that you can argue that the public recognizes as being a trademark, and the Patent and Trademark Office will protect that. Let's take colors. All right. Colors can be protected as a trademark. The color pink is protected as a trademark for home insulation. Okay. Owens Corning fought very hard and was able to show that the public recognized pink as a color for its insulation. Christian Louboutin has a red trademark on the sole of his shoes. So those are a couple of instances where you can have a trademark on color. You could also have a trademark on sound. For those of you who are Star Wars fans, the sound that is made by a lightsaber, that humming buzz, has been registered as a trademark by Lucasfilm. All right. Anybody who follows college football may have seen Boise State. Their football field, the turf or the carpet that they use is blue. They have a registered trademark in a blue football field instead of the traditional green turf. Scents can be protected as a trademark. Many perfume companies who have a unique scent to their products will try to get a trademark for that. Okay? So there's a lot of different things that can be protected as a trademark. Now, what do they look at? There's what's known as a DuPont factors, and in the trademark office, there are a list of about 10 different factors that the examiner is supposed to look at in making a determination whether there would be a confusion between two marks. All right. The most important one is how similar are the marks. The closely related marks that are in the same field, you're not going to be able to get protection on that. All right. If it's too similar, if it sounds the same, looks the same, spells the same, and it's for the same product or service, all the other factors are not going to usually help. So let's take an example. All right. If you're providing dental services and you're using a trademark that you've gotten, all right, and let's say it's cavity free, just to use something, and somebody else wants to use the same trademark in the dental field, it's going to have a very difficult time getting a registration on that. It's going to be impossible because the services are the same and the marks are the same. But let's say he was using cavity free in a construction or a metal processing business. All right. So he's able to make a very smooth metal product and it has no pits or cavities in them. And he tries to use the cavity free trademark. He may be able to get that because the services that he's offering are so different from your dental services that the ultimate customers are so different that there's very little likelihood of confusion. So those are some of the things they'll look at. They'll look at how similar are the marks, how similar are the products or the services, who are the ultimate customers. Sometimes you'll see a situation, particularly in the medical and dental area, where there'll be a product that's sold to dentists, let's say, and then there's a similar named product that's sold in hospitals. And, you know, the problem that you might have is you may think it's an infringement, but the patent office may say, well, no, because in the hospital setting, they have a purchasing agent. They're not dealing necessarily with the dentists. So maybe they'll let that go as a trademark. It depends. There's a very factually oriented. The cost of the product may be a difference that could be something that could be looked at. All right. The channels of trade, as we talked about. You know, sometimes some things are sold in a supermarket. Other things are sold, you know, in a different channel of trade. So these are the list of factors that, the patent office and the courts will look at in an infringement action and determining whether or not there is a likelihood of confusion.
Well, I think that's a whole other topic that's very interesting. It's one thing to get a patent, and it's another thing to have your idea be brought to market, and then it's another whole theater of defending the patent, which I'm sure can become extremely costly. Now, if you're a big corporation and you're defending a patent, you have big pockets. But if you are, someone, a layperson such as myself, then it becomes, another hurdle. So I think these are very important things to consider. And, one thing that I've learned over the years, because I personally have a tendency to complicate things myself, and there's one simple rule, and I'm going to say it, it's called the KISS rule. And I'm sorry, but I will say it, it's keep it simple, stupid. So what happens is sometimes you have this really good idea that's rather narrow. But then you start thinking, like I think, and I don't recommend this to anyone. You start thinking, how do I protect my little idea a little further? And then you start getting patents and splitting them up and putting different embodiments and different patents. And it gets extremely complicated. And sometimes the end product that's actually manufactured, if you're fortunate enough, looks completely different than the original patent. So my experience, and I will share it, is when you are convinced that the product that you want to create is ready, that's when you apply for a patent. Because once you start changing your mind 50 different ways and coming up with further ideas, it gets so complex and it gets expensive. Um, and difficult to market because we in this day and age we like simplicity as much as we have our lives enhanced by computers and everything is fast. People like simple, and that's something to touch on. I think it's my experience. Dr. Shah.
Keep it stupid simple is a good concept. I've heard that before from patent attorneys and trademark attorneys. Very important because we make things complicated. Simplicity is very important, but your claims at the end are what count. The rules are changing. Big corporations usually do have an upper hand because they can defend and argue. Because the argument with the trademark office, and Tom, correct me if I'm wrong, can go on for quite some time. A lot of back and forth. Somebody it gets published for opposition. That's like one of the last steps before it becomes completely published as your trademark. If nobody objects, but if somebody objects, you got to argue with them back and forth. And sometimes there's amendments needed to your mark. Sometimes they're not. Sometimes you want to take it on, then it becomes a court matter, and then they come after your profits that you have made using that trademark or that patent. So it can take a long process to actually enforce or object to a patent or trademark, and it can be very costly. You're right. The corporations have the upper hand if you don't want to fight them.
There's no question about that. But one of the things you really need to do, whether you file for a patent or you file for a trademark, is to do a search first to hopefully eliminate those areas where you're too close to somebody else. And the search is not just of the Patent and Trademark Office, but, particularly in the trademark area, think about what other famous marks are out there. Be open and to, search not just in your specific area. So, for instance, one of the problems people have is they're under the impression that a small change to a trademark makes it easier for you to register it. That's not true, because the courts and the patent office look at what the ordinary purchaser would go ahead and understand from that. And let's be honest, the ordinary purchaser is not a very careful purchaser. They don't always have the two products side by side where they can tell the difference between them. So the courts and the patent office are very solicitous of that. So you really need to go ahead and, when you're having a search done, look at not just the words themselves, but sometimes the meanings, the synonyms, all right, the spellings. Just because you spell extra XTRA is not going to get you around somebody who's using EXTRA, all right? And also keep in mind that how you market the product can be very important also. Two trademarks that are very different can be marketed the same way, so they come out looking similar by going ahead and having the same label colors on, the same fonts. You have to go ahead and really take a look at what the marketplace is when you're applying for a trademark and when you're going to use it. And it's very similar in the patent area. The patent office goes back, you can do an online word search for the patent office going back to 76. And that's fabulous for a lot of technology. If you're in the biotech area, going back to 76, there's nothing much before that you would really be concerned about. All right. But in other technologies, particularly in the mechanical area, 76 is not that valuable a date because, there was a lot of mechanical devices that go back a long time and were very, there was mechanical engineers working on stuff in the teens, in the 20s and 30s. And depending on what the product is, you really need to go back and search some of the earlier stuff. I'm sorry, I can't hear you, Doctor.
Yeah, neither can I. Dr.
I
Shah?
don't know what your take is on that, Dr. Krostev. Tom, that was a good portion. So what you insinuated was that they look at color, your design, the way the similarities of them are, the design features, the dominant portion of the mark, and what else does the examiner look at after you did your trademark search and somebody objects and all of that?
Well, they look at the sophistication of the purchases. They also look at your good faith. Are you trying to come as close to the line as possible? All right. Or, is this something that is, a legitimate, change that you made? Are you using terms that are, very descriptive? There's a lot of factors that the examiners and the courts look at in determining whether or not there is infringement. And, those are things that are very important in the overall calculus that you have to take into consideration when you're selecting a mark.
And whose obligation is to prove that there has been a cause of confusion in commerce? Is it the aggressor, the person that is actually objecting? Do they have to do surveys? Do they have to have proof? Because anybody can claim, yeah, this other guy's name is similar to mine, and now I want to go after their profits. There's got to be a process in place, right?
Yeah, there is a process, and a lot depends on how famous the mark is. If it's a very famous mark, even though you're using it in a different technology, they're going to have protection in that area because people are going to think that they probably license it to you. So, for example, if you're going to use the name Tiffany in something, they're going to come after you whether you're making jewelry or you're making shoes or whatever. All right. It's a very famous mark. And, people are going to think, well, you must have gotten a license from Tiffany. So there would be infringement. For other products, it can be totally different. If it's a very descriptive term, the trademark owner may not have very many rights at all. There may be a lot of companies out there that are using very similar marks. And therefore, the scope of the trademark may be very, very narrow because everybody else is using extra as an adjective for some product. So the fact that both of you are using extra may not be very protectable as far as
So, if
it's very factually oriented. Go ahead.
I'm sorry. So if I may, Tom, can we assume that our audience right now has an idea, something that they're not sure how to pursue? Can you walk us from your experience just through the entire process? So you meet on the first day, you do an interview, you get an idea of what's going on, you advise them one way or another. Then provisional application perhaps or not. But then how long does it take to apply and when do you do it for the utility? And then typically, maybe you can explain to us how initially the patent office, generally likes to decline things. And sometimes they cite information that is completely unrelated to the product. I mean, you may be going into dentistry and they may cite you a toy for children, which is exactly what happened in my case.
They do that often, Pavel, don't they? The first response is usually, hey.
The first response is always a no. And, but the thing is, it becomes a complex process and you go back and forth. But ultimately, if you can just walk our audience on a very basic level for lay people, let's call ourselves, because we're not patent attorneys here, walk us through the process, how long it takes typically for an average patent. I'm not talking about an iPhone that has 1,000 patents. I'm talking about, someone invents a new toothbrush. How do you start the process? How does it happen? How long does it take? What is involved? Please.
All right. So let's take a toothbrush, for instance. First step would be, as you're developing this toothbrush, obviously you're going to know about other toothbrushes that are out there. All right, bring those to the attention of your attorney. All right, because some of these may not have been patented and they would not come out in the search. So maybe there are certain features of those toothbrushes that may be relevant, and it's always to your advantage down the road to go ahead and tell the examiner about any prior art that you're aware of. The first step when you meet with the attorney, you're going to go ahead and tell the invention to them. First thing that the attorney will suggest that either you or he does a search to see what's out there. As we talked about, toothbrushes have been around since people used twigs out in the jungles years ago. So, there's going to be a lot of technology out there on toothbrushes, and you're not going to be able to rely solely on what goes back to 1976. It's going to have to be a more in-depth search. All right. Once the search comes back, it takes usually about 2 weeks to do the search. All right. And, one thing you have to be aware of, that there's a lot of different ways you can search something. And most attorneys recommend that you only do the United States Patent and Trademark Office because it can get very expensive doing some of these other searches. For instance, there's the European Patent Office that you can search, right? You could also search the Japanese Patent Office. You could also search the Chinese Patent Office. And you could also do what's known as a literature search for some of these things to see whether or not somebody wrote a thesis or something like that on a related subject that might be relevant. So you have to set some parameters as far as to how much you want to spend, because if you're going to search the Japanese Patent Office, that can get very expensive, because not only do you have to hire somebody in Japan to do that search, in order for it to make much sense to you, you're going to have some translations done of some of the, more relevant products. So many people make a business decision to say, we're really only going to do the U.S. Patent Office first. But if this is an extremely valuable product that, could be groundbreaking in a particular field, you may want to go ahead and have a broader search done, okay, at least at some point, during the whole process, to make sure you understand fully what kind of prior art is out there that could present a problem to your patent down the road if you're in litigation. Because if you sue somebody and it's a very valuable patent, they are going to do these searches down the road. At that point, hopefully, you have gone ahead and done the search too, because your product is doing well. And so you can go ahead and address those issues somewhere during the prosecution of the patent application. So let's go back. You get the search results. They look fine. You go ahead, you file the provisional application. Some people don't necessarily want to file the provisional application. They want to go directly to the utility application. That's fine. But those instances are typically where the product is fully developed, and many inventors really don't have a good handle on what the end result of their invention is going to be, what the product ultimately is going to be. They haven't talked to a manufacturer. They don't know whether or not, this aspect is going to be too expensive to make. So, I recommend a lot of times that, you file the provisional, keeps your options open, because during that year, you're going to do a lot more research on this, talking to manufacturers, talking to potential salespeople, talking to people in the market. What is it that you really want to protect? And then at the end of the year, then you file the utility application. So the provisional application gets filed, doesn't take very long to prepare frequently, but the more detail you can put in there, the better off you are. All right. Yes, you can file just the drawings, but you really need to have some textual matter in there to explain the drawings. A lot of times you want to put in whatever information you know about your invention. The other thing you want to do is you have to recognize the fact that the patent examiner does not look at the provisional. It's purely a filing to give you a date, a filing date to beat somebody else who comes after you. It also helps prevent publications or patents filed elsewhere from being prior art to your invention. So it does cut off a lot of that potential prior art. At the end of the year, you have to think about what are you going to do with respect to the utility application. Have you made changes to it? Have you made improvements? Maybe the thing you've done is you've learned that there's not much value to the provisional, but you made these changes in this area here, and that's where you want to go ahead and protect that. You may end up filing another provisional and forgetting about the first one if you made so many changes to it, but it all depends on the particular factual circumstance. All right, once you file the utility, it takes, and one of the things it's very important both from the patent standpoint and from the copyright standpoint if you're working with somebody. If you hire somebody to do the work with you or for you, make sure that they assign their rights to you and do that as soon as you can in the process, because, technically they own what they develop unless you have a writing that transfers that technology to you. And it can be a problem down the road if there is a falling out and you don't get this agreement in writing. So if you hire an engineer to help you, make sure in the discussions with them, you're paying them to do certain work. You're going to own whatever work they do. Get that down in writing, because that will save you a lot of grief and aggravation down the road. You want them to make sure that they'll sign any papers that need to be filed with the Patent and Trademark Office or with the Copyright Office, and you get that down in writing. So you file your application. The application typically has a very detailed description of how your invention works. There'll be drawings, and then there'll be at the end of it claims. There's a series of claims that you will have, and that covers in words what it is your invention covers. All right, and those words are very difficult to understand by the layperson because it's sort of counterintuitive to you when you're looking at that, because a broader claim is one that says less than one that has a lot of detail. All right, because if you write a claim that says you have to have items A, B, C, and D, if somebody only has A, B, and C in their competing product, there's no infringement. So you have to look at the claims very carefully. And, you want to file it with as broad a claims as you can, but you have to recognize that you may have to narrow them down the road. And maybe you go ahead and file with some broad claims and some narrow claims in there, so you make sure you cover the invention as well as you can. All right, once it goes to the patent office, it takes at least a year. Sometimes you get lucky and it's shorter, but it's going to take at least a year. Sometimes it could take 2 or 3 years before you really hear anything from the patent office. And it will go to an examiner who'll do his own search, and they tend to look at these claims a little differently than you would. All right, they try to read them as broadly as possible. So, one of the questions or one of the issues that, was talked about, they go ahead and file a patent application on a dental product, and all of a sudden he's citing toys. Well, he's citing a particular aspect of that toy, probably a mechanical aspect, to show that, you doing this mechanical technique in your dental invention is known in the toy industry. And it's not necessarily in the toy industry. What he's really saying is it is known to people who have knowledge of mechanical engineering, okay? Whether it be in the toy industry, whether it be in this industry or that industry, it's something that people in the mechanical engineering field would know about. And that's why, when you argue, well, he's in the toy business, it's not a dental business, it doesn't get very far. What you have to show in the response to that type of rejection is that you're not doing what's in that toy patent. you're doing something different, and you have to focus on those differences in order to get your patent. That's what goes on there. So, you will get an office action at some point. I'll be perfectly frank with you. If you get a notice of allowance on the first go round, you just got to think to yourself, well, maybe I didn't claim it as broadly as I should have. Maybe we want to go back to the patent office and file another application based on that and see if we can get something broader, because, you may have gone ahead and just may have claims that are just too narrow.
I see Pavel laughing because we have had to play this game many, many times.
Well, it gets exciting, and it's an up and down roller coaster. Whenever you get an update from your patent attorney, you open it, and one day it's up, one day it's down, one day it's a little bit of an argument that there needs to be addressed. It's a special pleasure when you do that.
It's a process, but when you wait for 6 months to a year or more to get a response, patent,
you have to be very patient. But one thing I want to bring up, and I don't think we've touched on it today, is the NDAs, non-disclosure agreements in general. And usually when look, I'm a very open book with everyone. When I have a new idea, I go tell all my friends. When I have a problem, I go tell all my friends. I have a big mouth, and that's unfortunate. That's who I am. So let's say I have a new idea tomorrow. I tell a few people. Do I
tell anybody?
Sign a non-disclosure agreement? What is a non-disclosure agreement? What does it protect you from? When do we employ one? I think it's something that people need to understand, and how it protects us.
Well, to add to that, Pavel, also, you have an idea, you need a prototype, you need companies to make it, right? You need companies to make it, you need to talk to people, you need to get your dimensions right, you need to select your materials properly. You got to come out with it. Pavel makes a great point, but the flip side of that coin is that NDAs are sometimes not enforceable. So how do you get your stuff done so you can raise money if you need money to make your product, bring investors around? That's a huge point. Now you have the idea. You can't file for a provision. Should we file the provisional first, or should we have a functional prototype? Those are all questions that are very viable, Pavel. Thank you for that.
Okay, so let's talk about NDAs. All right. NDAs are very valuable, and the courts will enforce them. There was a case down in Delaware recently where, it was Merrill Lynch, and they enforced that, much to the surprise of the people who were not following the terms of that NDA. So courts will enforce them. All right. It's very important to have an NDA with somebody, and, because you don't want them to go ahead and reveal your invention, or particularly any changes to your invention, because you may file your provisional application, and, 2 months later, you've been thinking about it, and, you haven't made any changes to the provisional application, but you have some new ideas and you want to talk to somebody about it. Yes, you have the protection of the provisional application, but you've made some changes, or you've gotten some other ideas, and it's not in the provisional. So an NDA is very important, and I recommend, before you tell anybody about your invention, and I'm not talking about telling your wife or telling your kids, all right, because they're not going into the details of it, all right? But, before you go ahead and talk to any manufacturer, any salespeople, that you have an NDA with them. It's very important. Okay. And, they will enforce them. Right.
That's great to know. My wife has a contract with me. She can enforce in California very readily without the paper signed. So, but yeah, that's a good point. So sometimes it's a very tricky business, Tom, because you have the NDA in place, and these guys take your idea and go to a third party. A third party modifies your idea a little bit, and next thing you know, it's on the market, or it pops out of China. How are you going to enforce something that's being made in China?
Okay, so one of the problems with dealing with China is that many of the NDAs that people try to have them sign off on will say that it has to be enforced here in the United States. You can't do that with Chinese companies.
Of course.
You have to have what's known as an NNN agreement, okay? And basically, that is an agreement where the Chinese courts will enforce it. And they will enforce those agreements.
Really?
All right. But if you go ahead and sue a Chinese company here in the States, you're going to have a tough time getting a Chinese court to enforce that U.S. judgment. So you're really just running into a big problem here in the United States when you don't go after them in China.
Yes, and I mean they're a lot looser on IP than we are here in the States, but I mean they are part of the patent cooperation treaty. So it gets very expensive to go down there and enforce contracts and fight with the
Right.
company.
And what you really need to do is think about customs. You can have, customs will grant seizure orders of products that come in with, different infringing trademarks or infringing patents and things like that. Another issue is, you might want to think of if you have a Chinese supplier, you might want to consider having a design patent because it makes sometimes it a little easier to enforce a design patent against a company that's shipping products in from China than it would be a mechanical patent or a utility patent. All right, because it's easier for the customs guy to say, "Oh yeah, that's the same," and he's focusing on the design patent. Because one of the issues sometimes you have in China is, when they make 1,000 of these for you, they're making another 100 or 200 to ship out themselves. And, the design patent can be very helpful in those types of situations. Ownership of the mold can be very helpful as well.
So third parties, the NDAs, back to the NDAs, how much, you call a contract manufacturer or prototype designer, they're going to want your designs right off the bat. They're pretty reliable here in the States because they can go quickly out of business if people start complaining about the IP popping up elsewhere after you had them make their prototypes.
Correct.
So those are pretty safe, I found, those kind of organizations that make you a prototype and prototype 2. But then in negotiations over an NDA, it's all time limiting. It takes forever, and they have their own NDAs that they like you to sign versus the NDA you want them to sign. What do you recommend there
Well, you have to look at what the NDA covers, and one of the big things that I am very concerned about is when the NDA that you get from them covers oral information or visual information. All right. There has to be some language in there that if they claim or you claim that the confidential information is oral or visual, that you have to go ahead and provide them with a writing that sets forth what that is that you're claiming, because otherwise it's a he said, she said situation. Oh, I showed you that. Well, you came through my plant and you saw that there. How do you go ahead and fight that argument that they didn't show you that? Unless there's some provision in there that if somebody claims it's oral or visual information that's confidential, that's protected, they have to define what that material is so you know what it is that they're claiming.
Excellent. Well, the NDA is a whole different beast, as you know.
But they can be very valuable. Don't ignore them, because without them, you don't have anything.
Certainly true as well. So, copyrights, a completely different beast. Can you? I'm not as familiar with copyrights. We've done some things on them. Explain to us a little bit more on what you recommend on slogans, certain intellectual property type writings that you want secured for your organization. Maybe we can learn something here, Pavel, too, because I know you're in the patent and trademark space, but copyrights are kind of another story.
Yes, they are. Copyrights are a very unique area. All right. So anytime you're going to have an advertising brochure prepared or you're going to put something up on your website, make sure you know what the source of that material is, particularly pictures. All right. You're going to put a picture of something on your website. Make sure your web designer goes ahead and gets a license for it or uses some of the free stuff that's out there that's clearly free. All right. Because there are programs that will search the internet for particular pieces of artwork, namely photographs, that all of a sudden you'll get a cease and desist letter and a big claim for 3, 4, 5,000 or more in damages because you use somebody's photo. The person who takes the photo is the owner of the copyright. So you got to make sure if you're going to go ahead and hire somebody to take pictures for you, make sure you have them assign the rights to the photo to you. May cost you a little more, but at the end of the day, you want to be able to do that. So let's talk about copyrights. Copyrights are accrued as soon as the work is created. The photographer takes the picture. All right. He has a copyright in that picture. He gives you a copy of it. What rights have you gotten? Basically none. So if you want to use that in any fashion, you have to get a license from the photographer. That also works with music. Never put any music on a website or play it in your office. You got to be very careful playing music in your office. All right. There are people from ASCAP and BMI that will go around listening for music. One of the big things that they've done for years is go ahead and gone into diners. And, the chef is in the back listening to the radio, and they'll come after you for you infringing their copyrights in the music. So if you're going to use music in your office, make sure you know where it's coming from and you have the right to do that. Right? It can get very expensive. And sometimes it's very difficult to determine who owns.
Can you explain this more? What are you referencing as to music? Everybody has a radio on, everybody playing CDs, they play music in restaurants and dental offices and medical offices.
You could have ASCAP show up one day and say, you owe us X dollars because you have been playing music in a commercial setting without a license.
From the radio?
Yes, from a radio. All right. ASCAP went after the Girl Scouts. All right. Because the Girl Scouts were singing songs that were protected by copyrights around the campfire during summer camp out in California. Now, they got a lot of blowback from the public on that. But at the end of the day, they did have rights to that music, and you don't have the right to go ahead and play that music. And you don't have a license to play music in your office that's owned by somebody else.
Even if the radio is playing it?
Yes. This music that you have in elevators and things like that. Yeah. It's background music. You have to go ahead and see where that's coming from. Do you have a license to do that? So let's say you want to, you have a restaurant or a bar, all right? And you bring a band in there on Saturday night to play some music. Somebody has to have a license to play that music. It might be the musician has acquired the license, or you may have to get it yourself. You just can't play music.
No, Facebook shut us a couple of times down when we had background music for these podiums that are doing displays. When they were doing their presentations, they would have a little background music, and it would shut the session down, and then we would have to fight it and have it cut out. I understand what you're saying, but you literally, what you're telling me right now, this law or this agency could shut down all of America because everybody's playing music in their organizations. Everywhere.
Let me tell you, they have people who go out searching for those instances. All right. Now, they would typically go to a diner or a restaurant and listen for that. Okay. And they will write you a cease and desist letter. They go after schools. All right. You know, when your kids are in school and their band is playing a song in the school, they have to have a license for that.
Well, I want to raise a question here, if I may. I've certainly had this issue. Sometimes I make videos while driving, while my radio is playing in the background, and then I've had the unfortunate occasion where Facebook knocks out my video and says you are infringing on copyrights.
Correct.
So now this question becomes, I mean, I'm not nothing bringing no politics in here to the equation, but as of recently, an attention, some ideas, not ideas, some things I saw on Facebook where a very popular song was being played by a very, very popular individual. And my question right away in my mind became, well, how come Facebook is not blocking this particular individual that the whole world knows now, but yet they're playing with me and me playing music in the background? So makes no sense to me, but what's going on with that?
Okay. There was an instance where I believe Trump was playing a song at one of his events.
Rallies.
And the artist was all bent out of shape about that.
I remember that.
Okay. But interesting, Trump got a license for that. Okay.
I'm referring to Trump, though.
You know, the artist really didn't have much leg to stand on because he had a license. And that's what happens. You have to get a license for that.
I was referring to
These are available, but most people don't even think about it until after something happens.
After something happens. That's very interesting, and it's a wake-up call. But again, also, Tom, they say that you commit several felonies a day, but you don't get caught. People don't, people are going to have a really hard time shutting their radios and their music down in their businesses.
They will until they get the cease and desist letter. And then all of a sudden it's a different story. I've had school districts contact me because, they've done things with music that
it's amazing
that they've gotten caught on. And, the copyright becomes a very powerful instrument and a very expensive instrument in a lot of instances. So, for example, there was one school district we ran across that they had a license to go ahead and play certain music, all right, at their events. But in this instance, they were not just playing the music, they were going ahead and doing a dance or a dramatic rendition with the music. Okay, so you had somebody up there who was doing more than just singing. They were, putting some acting emphasis on it. And the interesting thing was we found out that the person who had the license for the music wasn't the same person who had the license for the dramatic rendition with that music. So, we had to go ahead and get the license for not just the music, but we had to make sure we got the dramatic rendition of that covered. And, copyrights covers the sound, the music, the notes. It covers the words. All right. It covers the performance. There's a lot of ways to slice and dice.
So do you have to go through a formal process, or, you see on a lot of websites and a lot of other things that it says at so-and-so copyrighted. Do you actually go through a process to copyright things, or you just use your notification? Like for trademarks, you just put a TM up there to notify the public that either you are in the process of trademarking it or you're trademarking it, and when you get your registration, you put the R on there. What's the scenario with the copyrights? How legitimate is just putting an at copyright next to your whatever it is?
Okay. Copyrights are acquired from the creation of the work. So when you go ahead and write the song, you have created a copyrighted work in the song. You can register that, and there's certain advantages to registering it. Primary advantage to registering there is twofold. One is you get the right to sue somebody for infringement. You can't sue anybody for copyright infringement unless you've registered the trademark. Registered the copyright. But you also have the right to what are known as statutory damages. Now, you're sitting home and you're putting a DVD on in your player there, and you're watching it on the TV, and you see this FBI notice up there, and all this stuff. It's protected by copyright, and it talks about some very hefty damages that you could be liable for. Those are what are known as statutory damages, and the value of statutory damages is in the copyright area is like, let's say you wanted to download the song from Apple Music, and Apple Music charges you $1.29 for that song to put it on your phone and to play it personally. That's the value of that song. But, Apple's not going to come, or the owner of the copyright's not going to come after you for that $1.29. It doesn't become, worthwhile commercially. But, maybe you have 10 songs and, you've infringed it. So you can be liable for statutory damages, which can be $750 per infringement. So all of a sudden, you're talking about $750 times 10, which is $7,500. And that was one of the things that people who, if you remember Napster a number of years ago, a lot of the college kids would go ahead and, put hundreds of songs on available through Napster, which was a sharing program. And the owner of the copyrights, the music companies, would come after that and say, okay, you got 400 songs. We want $10 a song. And, they would get it. And, Junior wasn't going ahead and paying that $4,000. Dad was. And so copyright can be very powerful.
Oh, expensive to file for copyright?
Dirt cheap.
Really?
Yes. Compared to patents, compared to trademarks, it's very inexpensive. Now, there's a lot of times people don't register right away because they don't know what's going to be valuable to them. All right. So, for example, like, the daily newspapers don't always register every newspaper every day. Right. A lot of them may do that, but in these times they may hold off on that. All right. But, anytime you create multiple works, you're going to file multiple copyrights.
So, Dr. Pavel, you have had the pleasure of working with Tom on 13 different projects, if I understand correctly. What has your experience been? Do you recommend our colleagues look into it that are wanting to innovate, that want to get into the space, that want to do less dentistry, do more on the innovation side, which there's plenty of our colleagues that are in different spaces than just clinical practice. What are your thoughts on your relationship with Mr. Tom?
Well, that's a great question, and thank you for having this partner. But what I encourage everyone: follow your dreams. Plan something, dream something, execute it. It takes time, it takes energy, it takes knowing people and connecting with the right people who will make your dreams come true. My experience with Tom, look, I've known Tom probably for close to 10 years now. He's an amazing man, a great friend, and he's guided me through my journey with patenting. And now, like I said, I just got to them. I have 10 of them. But it's not about me here. It's about encouraging our colleagues and our professional friends. When you have a dream, when you think you may change the world, do it not for necessarily financial gain. Do it so you can leave a mark. Do it so that perhaps you may contribute something to the profession that you're involved in. My goals for doing these things, and I'll be very blunt, was not monetary gain. It was, I want my daughters one day to be proud of what their dad maybe changed a little bit in dentistry. That's the bottom line. Now, if I make a few dollars, I make a few dollars. That's wonderful. But man, Tom, I thank you personally, and you know it's been really a treasure to have you as a friend. More importantly than a patent attorney, and certainly you are, in my book, the finest patent attorney in the world, and you were very well quoted by being acknowledged for that. But thank you. It's been a pleasure, Tom, to know you, and to a friend like you. And of course, today we've sort of brought something new to the table on Global Summits. And Dr. Shah is a forward thinker. We try to engage our audience, not for our personal gain, but we want to share our knowledge, share our beliefs. And, if we can teach you something new, we're here to do it for you. And God bless America. And thanks again, guys, for having this beautiful show. Dr. Shah, I turn it over to you for the closing and the questions. Tom, thank you for coming.
Pleasure. Thank you for having me.
Just on a note to finish, thank you for your patriotic attire today, Dr. Pavel. And our vast majority of our audience from the United States, but we have a very, very large global following. And Tom, I'd just like to tell you it's one of our higher end special sessions where we have had this shared already 335 times on different groups that are related to healthcare and dentistry, as well as privately. And over 5,000 people watching live from around the world. Hopefully that number from our historic data triples and quadruples within the first 24 hours. And I hope that you will get some responses that you can help some of our colleagues get on the right track. A lot of us, it's not just Pavel and I that are in the same shoes. There's many, many, many colleagues that are constantly inventing and wanting to get into the invention space. That's why we did this special edition.
Well, I'm very happy to answer any questions that anybody has. They can email me, give me a call. I'm available to answer those questions.
Ladies and gentlemen, the email and address and phone numbers have been put to the side of this thread. Feel free to reach out to Tom, and wishing you guys all the best of luck in your innovation and new products and services that you will bring to the market.
Thank you, guys. God bless America.
My pleasure. Nice to be here today.
Thanks, guys. Take care.